Good morning.
Morning.
I'll take the register so we could put the names down. You all could give me your names.
Dominic Roberts. Morning.
Morning.
Danico Major.
Olivia Ferguson.
Kendra Jones.
Okay. Okay, so that's Dominic Roberts, Daniqua Major, Olivia Ferguson, and Kendra Jones. All right. Okay, in reviewing Unit 4, what are the requirements for creating a trust? Anyone heard me?
Some subjects as a friend.
Can you hear me?
Yes.
You were saying the three requirements for trust.
For creating a trust.
Yeah. Would it be the existence of the three certainties,
Mhm.
satisfaction of any formal requirements which may be laid down in statute for the creation of a trust, and transfer of the subject matter of the trust by the settlor to the trustee in accordance with the formal method process laid down in law?
Right, that's the three requirements for creating the trust. What the perpetuity period is all about. Just a quick summary, anybody?
The perpetuity period starts on the date the instrument takes effect, which may be the date of the testator's death, if the gift is by will, or the date of the instrument.
Mhm.
Example is an inter vivos gift. The
Right.
period, the period terminates after the lifetime or lifetimes of the life or lives and being plus 21 years.
And what happened, what has changed about that? What changed dealing with perpetuity period? What changed it? Anything changed?
Is it that it could be amended? It was amended? by the
Was amended.
Trust Act, Section 18. The court has the power to extend or increase the perpetuity period stipulated in the trust instrument by up to 150 years for the creation.
What happened, what happened with the perpetuity rule though? What happened with that? So two things happened, what two acts happened?
You're talking about that it was abolished?
Pardon me?
That it was abolished?
What is the act? What's the legislation?
RAPAA.
Yeah, what is that act? What that is called? What's the name of the act?
Rule Against Perpetuities Abolition Act, 2011.
2011, and what's the other, what else happened? What other,
An amendment to the Trust Act, 2011.
right, so when those two came into effect, what happened?
Perpetuity period in Bahamas was either 150 years from the time a gift is made.
So what could have happened? They could have what? According to these acts, you could have amended the perpetuity period if the trust was created before these enactment.
Before December 30th, 2011.
Right. Or what happens?
The trustees must make an application to the court for the court to declare that the rule against perpetuity has been abolished by virtue of the application of the RAPAA to that particular disposition.
Okay, when do we apply to the court? When it's before or after?
If it's before the December 30th, 2011.
Right. And after that, who could extend or increase that time?
The court,
No, after December 2011. Who would do it? Who would extend or increase or amend the perpetuity period? According to the Trustee Act.
The power holder.
Right, the power holder. So the power holder will do it after the period, and you have to apply to the court before the period, eh? What case, the case Night and Night helps us with?
It identified the three certainties, saying that a trust, for a trust to be established, the three certainties have to be stated.
And what are the three certainties?
Certainty of object, certainty of subject matter,
uncertainty of words of intention.
certainty of intention.
What is the test for certainty of objects in a fixed and in a discretionary trust? What's the test?
We should be able to say with certainty whether any given individual is or is not a member of any particular class.
And what that's for?
The Prostylin test.
Which one that is?
You ask for the certainty of object, right?
Right, which test that is? For the fixed or discretionary?
That's for discretionary.
Okay. What's for the fixed?
The certainty of object is that it must be possible for the trustees to prepare a complete list of all the beneficiaries.
And if not possible, the trust is
Voided.
right. Right. What about the legality of the trust? What has to happen for it to be legal? What are the general principles for us to say it's legally a trust? Everybody else in the class, right?
Yes, ma'am.
That's fine.
I only learned from one person so far, two people. What is requirements, additional requirements for the validity of the trust?
The settler legal interest in the property must be transferred to the trustee
Mm-hmm.
according to law.
Right, and what's the prerequisite for him to transfer the property? The settler, what happens? Because he's transferring the property, how we know that's his own?
It must be legally and completely, it must be completely and properly constituted.
Right, so the property has to be whose property? How we know it's his own? It must be his property, eh?
Yes.
And what else about him? He must be what?
Of legal age and sound mind.
Right, so he has to be, first of all, not a minor because the minor can't contract, eh?
That's right.
What they say about minors as it pertains to the trust.
They can create the trust of equitable interest in property, but it will become voidable for the purpose of the law until they reach the age of 18.
And then thereafter they can do what?
Become a resulting or constructive trustee.
They'll become that under certain instances, but once they have the equitable interest in the property, it's voidable until they're 18 and then they can legally enforce it under certain,
Certain conditions.
right. But they, under common law, they can also become a resulting or constructive trustee under circumstances. What is a resulting or constructive trustee? What is that person? How do you become a resulting trustee?
Is that when the settler failed to express his intentions?
Clearly,
Yeah.
What he did, what happened? So in the instance, let's give an instance. What case helps us with the resulting trust?
V. Vanderbilt's
Yeah,
trust.
right. So what happened? He may have done what? Just an example of a resulting trust for us to recollect.
Settler failed to express his intention of the trust clearly.
Right, so in one instance, let's give an example of what happens. The trustee does what? The settler does what? He creates a trust for someone for their lifetime. And what happens if the person, remember that?
Yeah. But okay. Where he created the trust for the lifetime, something with Amos, and Amos
Right.
died before the money was used to go back to run back to the settler.
So what happens is a resulting trust for who? Where the money goes to, who the money goes to,
Oh, back to the settler.
right? So it's a resulting trust for the settler, eh?
Yeah.
Right. So it goes back to the settler's estate. The trust is now, it results back. So that's a resulting trust. What about constructive trust? How do we become a constructive trustee?
Is that when the trustee acts on personal interests and it conflicts with their duty?
Right, so they benefit from their position as the trustee, right?
Right.
So whatever they benefit as a result of their position is now
A part of the trust?
benefit for the trust, for the beneficiaries of the,
Beneficiaries, yeah.
would they continue to be trustee? The trustee who was breached his obligation?
No.
Right, so he's no longer a trustee really. He just, the property that he held is now, he's a constructive trustee for that property, which he would have benefited from as a result of his position as trustee.
Mhm.
Okay, so we on to unit 5. I sent you an email this morning. I don't know if everyone was able to look, but I sent you some information on some trust cases as well as some questions you could use for study purposes. And I sent you the cases on this chapter as well. So you would have those for unit 5, I sent you Chalaram v. Chalaram, I sent you McPhail and Dalton, Visa v. Chase Manhattan, and v. Jardine. So that was sent to the email this morning. Now I have so far registered Kendra Jones, Olivia Ferguson, Daniqua Major, and Dominique Roberts. I think that was Tanisha speaking, right?
Yes, ma'am.
Tanisha Knowles. Anybody else? I don't have. Who's here?
Siri and Bristol.
Yeah, I don't have you. No. Okay, I don't have you. Yes.
Shanice Rule.
Yes, I don't have you. Okay. Okay, so I have 2, 4, 6, 7 people. Okay.
Ms. Dorset, quick question. You had me down for last class as well? You had me in last week's session?
I did not. Okay, Shanice, you were there last session, eh?
Yes, ma'am, I was.
Okay. No, I didn't have you, so I put you down now.
Okay.
All right. Okay, so let's move on to unit 5. After we would have completed this unit, it's a short unit. So you all have a lot of time to read over the information I sent you. We'd understand how and when trustees are appointed to a trust, the actions that trustees should take before appointment, gain information on the requirements to act as a trustee, and understand the law relating to the appointment of trustees. Now, just before we move on, I just want to make sure you would have understood so far from our introduction to now, you all have a understanding of what we were going through. Are you confused or it's getting clearer?
It's clear. It's clear. Just the perpetuities I have to get really down pat.
Okay, that one isn't so bad because it's really, that one a little more straightforward. It's just to read it a little bit because you have to wrap your mind around it a little bit more. That's all about it. Because it gets a little confusing, but once you read that same section that they refer to and you see what the difference is, it'll be clearer for you.
Yes, ma'am.
But all of the other chapters, you all have a good understanding to see how it's expanding, right?
Yes,
Right, so everything what we do continuously expands, so it's just like it's repeating itself. But it's just a little bit more explanation in each chapter. Okay. Who begins today? Who read first last week? We need somebody new this week to give the
I can
order.
read.
Okay, good stuff.
You want me to go ahead?
Yes, please.
Okay. Who may be a trustee? Any individual of who is of sound mind and not legally
Right, they have it wrong. It's supposed to be who is of.
sound mind.
Yes.
Right, okay. And not legally declared a bankrupt may act as a trustee. Additionally, since a trustee must be the legal owner of property, including real property, it is often required that trustees also be of legal age, which is 18 years, particularly in light of the fact that minors cannot hold a legal interest in land.
Because trustees hold legal interest in the land, eh? We have to convey the property to them, right?
Right.
So the minors can't be a trustee based on that fact in particular. Okay.
Due to the nature of the duties and responsibilities of a trustee, it is highly recommended that a trustee also possess a high level of integrity, trustworthiness, commercial awareness, and due skill and care. A corporation may also act as a trustee or co-trustee with another individual or corporation. As mentioned previously, a corporation wishing to act a professional trustee in the Bahamas must obtain a restricted license or non-restricted license from the Central Bank of the Bahamas.
Now, what we say about the corporation acting as trustee, what we say about their shareholders? Well, as we say, the company only needs 2 shareholders, and the trust, what we say they need to have, how many shareholders? This was from our introduction. Remember, we said they need to have 5?
5 and no less than 2.
Right, so remember we have say 2, but it's recommended that they have 5 in the instance where they're acting as trustee.
Yes, ma'am.
Yes. Okay, go ahead.
Professional trustees are often held to a higher legal standard of duty, care, and skill than individual or personal trustees, since they represent themselves as possessing certain specialized knowledge and skills in trust administration. Whether a trustee is an individual or corporation, It is important to note that the duties and responsibilities of a trustee are very onerous and time-consuming and require the full attention, skill, and care of the trustee in the administration of the trust, notwithstanding the fact that trustees may insure themselves against liability, except a breach of trust, from the trust fund under Section 23 of the Trustee Act 1998.
Okay, that's the one where we say it should be 24.
It's section
So-
24.
Okay, so Section 24.
Right.
Okay. The actions and decisions of the trustee are constantly under the scrutiny of the beneficiaries and the protector where applicable. And the potential for a breach of trust action is always existent, particularly when there are competing demands from different beneficiaries. Appointment of trustees. Trustees are normally appointed in the following circumstances. 1, at the creation of a trust. 2, as a substitute for a trustee of an existing trust who has died, retired, or been removed. 3, as an additional trustee to an existing trust.
Okay, so we
New
see
trust.
now
Go
we
ahead.
should pay particular attention to the fact of when the trustees are appointed. That's in section 42 of the Trustee Act. Okay? That section, this appointment comes under section 42 of the Trustee Act. So you could put a little note there so you'd be aware of that.
Section 2?
Section 42.
Okay. Section 42. Go on.
So trustees are appointed at these are instances, they're appointed at the creation of the trust as a substitute for a trustee of an existing trust who has died, who's retired, or who has been removed, or as an additional trustee to an existing trust. Okay? So we need to know when it can be appointed. Okay, go ahead.
The first trustees of a trust are appointed by the settlor in the trust instrument. The settlor inter vivos trust may appoint himself as a trustee or appoint other persons as trustees and transfer the trust property. When transferring to the trustee, the settlor must ensure that the proper method of transfer of the legal title is used. Once the valid transfer is completed, the trust will be completely constituted and will remain valid. In the circumstance where no trustees are appointed, the court may appoint trustees to administer to the trust in accordance with the terms of the trust. The trust property will vest in the first trustees of the trust and all subsequent trustees appointed, who will hold it jointly until such time as they die, retire, or are removed. A testator may also appoint trustees in his will, inter vivos. Here, the legal estate in the trust property vests automatically in the executors at his death. Where an administrator receives letters of administration, the title relates back to the death. The fact that the trustees appointed all predeceased, the testator or otherwise ceased to exist, or even that no trustees were originally appointed by the testator at all, or that they all disclaim the trust, or that the trustee appointed is legally incapable of taking, will not cause the trust to fail, even though the will may contain no provisions for the appointment of the trustees. Petite
So
equity.
notwithstanding, we don't have a trust, the trust will not fail for lack of a trustee, okay?
Petite equity and the law of trust. Here, the executors or administrators will be deemed to be constructive trustees until trustees are appointed by the court. Where the same person is appointed as executors and trustees of the will, once they have completed their duties as executors, the appointee automatically become trustees and the property vests in them in their new capacity. Note that there were Note that where, that's supposed to be where the property is land, right?
Yes.
Okay, so note that where the property is land, a deed of assent must be executed in their favor.
So the deed of assent is like a conveyance, so you must ensure that the property is properly transferred, eh? Isn't that a part of us making sure that it's created validly? You have to ensure that it's properly transferred, so the deed of assent is just like the conveyance in the form of an inter vivos trust. So in the testamentary trust, it comes as a deed of assent, and in the inter vivos trust, it would be a conveyance. Because they sometimes call the assent an assenting conveyance in some instances where there are letters of administration. Okay,
It is important that the trustees disclose any potential or existing conflict of interest prior to their appointment to a trust, as it is fundamental principle of trust law that a trustee may not place himself in a position where his duty as a trustee conflicts with his personal interests. Appointment of new trustees. Trust property vests jointly in all trustees, whether the trust is created inter vivos or by will. The power to appoint a trustee is often contained within the provisions of the trust instrument and may be given to a particular person, the trustees, or the settlor may reserve the power of appointment to himself. Unless the settlor reserves the power of appointment to himself in the trust instrument, he no longer has the power to write or to retire or remove trustees after the creation of the trust.
okay, what we talk about that settlor's appointment. What do we say about that? When he reserves this power of appointment to himself. What we call that?
It's a sham trust.
No, because the laws now provide, what new enactment help us to deal with that? We just talk about the settler directed trust and this power of appointment. Remember that?
Not really.
With this power holder and all of that? Look for it for me.
Can you repeat the question again, please? Hello?
Hi, I said, but the settler reserving powers, how can he reserve powers? What section allows him to do that?
Oh, is that section 24?
Section 24, that's section 24 is insurance, eh?
Under section 13 of the trustee amendment act.
What section 13?
Pardon?
What section 13 says?
Which inserts a new section.
Hey, yeah.
For settler directed trusts in relation to investment powers.
Section 13 says, what section 13 says?
Let's close it.
Look on page, now I don't know if this is your page. Look at the first page of unit 2. And that's paragraph, I don't know if that's your paragraph, 1, 2, 3, 4. Look at the 4th paragraph.
So section 3 of the trustee act.
Right, you remember this? You all remember this, where we say you could reserve some rights?
Yes.
So put that there on the side of that so you all will remember it. You see what I tell you, everything is just an expansion of what you've done before, so when you're supposed to be able to just reference it when you think, when they say in something, you say, oh, section 3 deals with that. You see, I already tell you what this does is it helps you to formulate your answers, and then this helps you with you getting 8 out of 10 compared to 10 out of 10, because you could even refer to the section. So if you are answering, unless the settler reserves the power of appointment to himself in the trust instrument, or as set out in section 3 of the trustee act, you see? So as much as you would say that, he's reserving it in the trust instrument as set out in section 3 of the trustee act, that means you not only know it can be an instrument that the trustee act allows him to reserve these rights of power to do certain things. He has certain powers he's reserved to himself to retire or remove trustees, okay? Everyone see what I'm saying?
Yes, sir.
Yes, ma'am.
Yes.
Yes, ma'am.
Go ahead.
The rules to the appointment of a trustee are set out in section 42(1) of the Act. Where a trustee, whether original or substituted, and whether appointed by the court or otherwise, is dead or desires to be discharged from all or any of the trusts or powers reposed in or conferred on him, or refuses or is unfit to act therein, or is incapable of acting therein, or is a minor, then subject to the restrictions imposed by this act on the number of trustees. A, the person or persons nominated for the purpose of appointing new trustees by the trust instrument, or if there are no such person or no such person able and willing to act, then the surviving or continuing trustee or trustees for the time being, or the personal representative of the last surviving or continuing trustee, may by deed appoint one or more other persons, whether or not residing in the Bahamas, and whether or not being the persons exercising the power to be a trustee or trustees in the place of the trustee so deceased, desiring to be discharged, refusing, or being unfit, or being incapable, or being a minor, as aforesaid. Ms. Dorset, could you say that in plain English for me, please? Because that's a lot of,
Just thinking the same thing.
yeah, that's a lot of or this or that, wherein thereafter, aforesaid, like that, they lost me. It's
Okay,
just too
so
much.
what they're saying is, notwithstanding, these things can happen, as mentioned before, because that's all they say in our said what was said right before this, like above. So our said is as said above. Those things that you just read.
Right.
These appointments can happen once it falls under this section. So in reading the sections, it's just a lot of legalese, but if you take out all the old language, it tells you how the trustees may or may not be appointed or be removed, who can do it. Because what section that you're referring to there?
It says section 42.
So section 42(1) of the Trustee Act grants statutory power to appoint trustees. So once the beneficiaries who are sui juris, and what beneficiaries are sui juris, what that means?
Sound mind and legal age.
Right, so they have to have the requisite mental and legal capacity, and they have to be also what? When we say sui juris, they have to be absolutely, so these beneficiaries must be, like the rule in Sanders 48 says, sui juris and what? What the rule in Sanders and 48 tells us about the beneficiaries? When they can terminate the trust, when they are sui juris and what?
Ascertain? No.
What they have to do in order to terminate the trust, if they're sui juris and what?
And an agreement to terminate the trust?
Say it again.
Hey, Crystal.
And an agreement, and it must all be ascertained.
Absolutely what? Entitled to what? In order for me to terminate the trust as a beneficiary, I have to be sui juris and absolutely entitled to the whole of the trust property.
Oh.
In order for me to terminate the trust, that's what the rule in Sanders and Vardier says. They talk about ascertain or ascertainable when it's a group. But as a beneficiary, if I am sui juris and absolutely entitled to the whole of the trust property, I can terminate the trust because I could say, I don't want you to do anything else for me. I'm absolutely entitled. You don't have discretion as to whether or not I get it. It's the trust says it's mine absolutely. So I can choose where I want the trust to continue. I could say, give me everything because it's absolutely mine. I'm fully vested in the trust property. So in that instance, they can appoint trustees as well, or they could remove trustees,
Right.
or they could terminate the trust. In section 42, the statutory power to appoint trustees is there, and it will be as long as the trustees numbers don't go beyond 4, because they don't, it's the statutory, the trustee act says it's not properly workable when it's over 4. You only can have up to 4 trustees. So that's what they're saying in that instance is the statutory, there's an express power, but they have in section 42 for you to appoint or remove trustees. And who's going to use that statutory power? If nobody can do it, who could appoint the trustee?
The settler?
The
who we gonna go to if none of these people can do it? Remember we say there may be no trust?
The court,
The court.
Right, right. So the trust will not fail because we have section 42. Where the statute gives power for a trustee to be appointed, but we'll have to go to the courts to enforce the law. Eh? Yes?
Yes, ma'am.
Well,
yes.
the settlor has not reserved these powers under section. Where the settlor has not reserved these powers to himself under section what?
3 of the trustee law.
Trustee Act, or where the beneficiaries are not what?
Of
Of
legal
sound right.
age.
Sue
And sound
juris
mind.
or sue juris and
Complete.
absolutely entitled to the trust, the whole of the trust property, or where there's no existing trustee to appoint, where we have trustees who have died or been removed because of breach, will the trust fail?
No.
No, ma'am.
No, because the statutory power is there in accordance with section
42
42 1.
trust.
Okay, so that makes it any clearer?
Yes.
That's all they're telling you, more or less. Section 42(1) will be enforced, but they can't exceed the number of trustees to, what's the number,
Or
right? So we may be able to appoint additional trustees to a trust if we feel one person isn't doing a job sufficiently enough. But if we already have 4 trustees, can we appoint an additional trustee? If 4 trustees, can we appoint an additional trustee?
no.
No, because we can't exceed 4, eh? Yes?
Yes.
Okay. And is any clearer? Any other questions on that one or no?
And that's fine.
Y'all understand what they saying?
Yes.
Okay. Okay, continue.
Persons nominated. A beneficiary who is nominated in the trust instrument to exercise the power of appointment of trustees may do so, notwithstanding the fact that his beneficial interest may already be, what?
It
May
may
be.
already be. That B shouldn't be there. Maybe the B cross out.
May already be disposed, as this specific power of appointment is not conditional upon his beneficial interest.
So the beneficiary may be nominated in the trust instrument, but a power of appointment for new trustees. But his beneficial interest may already be disposed of. He may not have any more beneficial interest in the trust. That doesn't preclude him from continuing to have that power to appoint trustees, new trustees. Because it's not conditional on his beneficial interest. His power of appointment has nothing to do with him being a beneficiary. Okay, go ahead.
Okay. A settler of an inter vivos trust may nominate himself as having the power to appoint new trustees. No matter the circumstance, all appointments of trustees must be made in accordance with the terms of the new trust instrument. The appointment of a new trustee is normally made by a deed of appointment executed by the parties, particularly where a new trustee has been appointed to replace a retiring trustee or as an additional trustee to an existing trust. Surviving or continuing trustees. A new trustee may be appointed not only by persons nominated in the trust instrument for purpose of appointing new trustees, but also by the surviving or continuing trustees or the personal representatives of the last surviving or continuing trustees by inter vivos trust only. The personal representative of the last surviving or continuing trustee is not required to exercise the power of appointment and may be forced to do so. The purpose is to enable a trustee who is disclaiming or retiring to appoint his successor. Also, all the surviving trustees together or a sole trustee to retire and at the same time appoint a new trustee or a new trustee to act in their or his place, which could not be done if this power was given to the continuing trustees or trustee in the prima facie sense.
On the face of it.
A consequence of the section is that an appointment of a new trustee made without a concurrence of a refusing or retiring trustee would be void. If the refusing or retiring trustee could show that the was competent, that should show that they were
competent.
okay. Could show that they were competent and willing to act and was not consulted.
So if the trustee who is there does not concur with the new appointment, which is made outside of them, so that means you appointing someone else, notwithstanding I'm competent enough to continue to act or be able for you to consult with me to appoint, then this new appointment will not stand. If the surviving or continuing or the surviving trustee can show they are competent and they were not consulted.
Okay.
Mm-hmm.
In the case of Rees Stonham's Settlement Trust 1951, a trustee had been replaced on the ground that he had remained outside the UK for more than 12 months. On his return, he sought to upset the appointment on the ground that he had not been consulted in the selection of the replacement trustee. The court held that he had no right to participate in the appointment, since the phrase refusing or retiring trustee did not include one who has been removed compulsorily on account of his absence from the jurisdiction. In Brockbank 1948, there was a dispute between the continuing trustees and the beneficiaries as to who should be appointed as a new trustee. The beneficiaries had no right to interfere in the exercise of the discretion which the legislator had given to the continuing trustees, even where, as in this case, the beneficiaries are all sejuries and absolutely entitled to the trust property, and therefore entitled to terminate the trust under the rule in Sanders versus Fortier. Personal representatives of the last surviving trustee. Where all the trustees of a will predecease the testator, the last of them to die is not a surviving or continuing trustee, and so his personal representatives are not entitled to appoint a new trustee. Nicholson versus Field, 1893. Therefore, the power is exercisable only the personal representative of a trustee, including a sole trustee, who was alive at the time when the trust came into effect.
So where the trustee predeceases the trust, the settler, the testator, I guess, they have no effect. That's what they're saying, more or less. His personal representatives are not now, it doesn't revert to his estate then, it's the trustee, because he predeceased the trust coming into being, more or less. Yes, you understand?
Somewhat.
So if you by will appoint let's just say you have a will
Mhm,
and you appoint your sister to be your trustee over your minor children.
mhm,
Your sister dies before you die,
mhm.
so she predeceases you.
Right.
Her children or her husband will not be able to appoint a new trustee.
Oh, okay.
See, that
Gotcha.
was for her benefit. That wasn't for the benefit of her estate. That was for her to do. And since she predeceases you, she doesn't have her estate. It doesn't go down. That's not rights of survivorship. It ends right there.
So it would be up to me to find
So
someone
you,
else.
right. So you could find someone else, or if you are incapable, I don't know if you, because that's an interview. So if it's an inter vivos trust and you've not reserved those powers to yourself, this is in this instance.
Mhm.
So I appointed you as trustee. Um, it wouldn't go for an inter vivos. Let's do it for the testamentary. So it, in any event, it doesn't pass over to your estate. So if I appoint you and I don't have any more powers of appointment as the settler, then perhaps the beneficiaries who are absolutely entitled can do it. If they don't do it, then where we'll go to,
The court.
right? Section, what, how's it? What section have the statutory power?
Section 42(1).
Right, section 42(1) will help us. Okay,
Okay.
go ahead.
Occasions for appointment of new trustees. New trustees may be appointed in the place of an outgoing trustee and in addition to trustees who are remaining in office. Replacement trustees. New trustees may be appointed as replacements in the following circumstances. Where a trustee is dead, includes a person nominated under a will who predeceases the testator, where a trustee remains out of the jurisdiction for a period of more than 12 months. This refers to continuous absence. The motive for the absence is irrelevant.
What case just tell you about this trustee being absent?
This was
You just read.
Restone Island Settlement Trust, 1951.
Right. Mm-hmm.
Where did I stop? Where a trustee desires to be discharged, whether from all or part of trust or powers conferred upon him. Where a trustee refuses to act. Where a trustee is unfit to act. Unfit refers to defects of character rather than medical infirmity. Example, bankruptcy, conviction of a crime. Where a trustee is incapable of acting, refers to physical or mental inability to attend to the administration of the trust, does not include bankruptcy. A trustee who is a minor may be replaced. Note that additional trustees may be appointed as long as the total number does not increase beyond 4 trustees. Appointment by the court. In exceptional circumstances and often as a last resort, the court may appoint the new trustee as a substitute for the trustee that has died, retired, or been removed, or as an additional trustee to an existing trust, taking into consideration the wishes of the settlor and the potential trustees impartially and his ability to further the interests of the beneficiaries and the trust generally, Section 48 of the Trustee Act. This is done wherever it is expedient, difficult, or impracticable to do so without the assistance of the court.
Okay, that's
The court,
expedient.
pardon?
That's expedient.
Expedient, sorry.
That's okay.
The court will not exercise its powers if an appointment may be made out of court by an express or statutory power Gibbon, 1882. The court will also not interfere if a person has an express or statutory power to appoint new trustees, even if requested by the beneficiaries.
Okay, when does the court step in? What section deals with the court stepping in? Where the court now has the power to appoint a new trustee, what section deals with that?
Is that section 42? What?
No, we just read it, section what?
48.
Right, so section 48. So now we know section 48 deals with the courts of power of appointment of the new trustee. And the statutory power to appoint new trustees is section 42(1), and the courts now stepping in is section 48.
I'm sorry, I'm jotting notes. You said the statutory is 40.
42(1), that's the statutory power to appoint trustees. And the court will step in to appoint, because this is the last resort, where there's nothing else there, the court will now step in to appoint a new trustee. That's settled in section 48 of the Act. And now our case Chalaram will tell us about this.
I'm still reading.
Chalaram, yes.
Okay. The case of Chalaram versus Chalaram, 1985. In determining whether the court will act with regard to the appointment and or removal of a trustee, the following considerations were made. The jurisdiction of the court, which was dependent upon the facts in this case, the interest and welfare of the beneficiaries, the actions of the trustees, those trustees who acted improperly or dishonestly and endangered the trust assets could be removed, the nature of the duties to be performed by the trustees, and whether such duties were of a particular personal or delicate nature.
Okay.
Is a charge relatives that will go in the court?
Okay, for some reason, your thing went down. I don't know what happened. You can hear me?
Yes. Did you hear what I read, or I need to read it over?
You are number 4, the nature, personal or delicate nature. You said anything after that?
Yes, I had a question. This case with Chalaram, are these relatives that went to court or something?
Okay, so I gave you all Chalaram. Let's go. You all were able to look at it or no? What I sent you?
You mean this morning?
Yeah, no, right?
No.
So
No.
Chalaram was 2 brothers. They were members of an Indian family, and they set up a discretionary settlement for the benefit of other members of their family. In this instance, they did it in India for taxation and exchange control, to avoid Indian taxation and exchange control. They set it up from the Indian bar, but all of the beneficiaries were mostly in London. It was for their businesses in different places, but the beneficiaries were in London and the trustees were in London. Yes? The trustees, however, never made a distribution. As much money as the trust had, they never made any distribution of capital or income to the beneficiaries. So the beneficiaries sought removal of the trustees and appointment of new trustees in England. Now, what they're saying is you don't have jurisdiction because this is a foreign settlement, eh? And they're saying the proper law of the settlement would have been Indian law. However, the courts, because the trustees are saying the court in London had no jurisdiction. So the court says, notwithstanding whether foreign law, the foreign trust is no distinction, if the beneficiaries and all their connection with India, they were in London, it didn't matter. They said the English proceedings could take place because, first of all, the trustees were in London, the beneficiaries were in London, so it was the most convenient forum for them to hear the matter. It would take forever for them to get a date in Indian courts. And notwithstanding that, the solicitors, who were the trustees, took service of the writ in England. So the jurisdiction to enforce rights could be made in personam, which what we say is in personam. You remember in personam? Anyone?
Meaning in person?
Right, so it could be done in person right there because the people were there. Therefore, what we say in there, the jurisdiction of the courts were dependent on
The facts in the case,
yeah, so the facts in the case,
the interest and welfare of the beneficiaries,
right.
the acts of the trustees, those trustees.
That wasn't the case in that instance, but the fact that the jurisdiction of the court would be dependent upon the facts in the case, and that was dependent upon the facts in this case, because notwithstanding it was done in India, the settlers would, the settler was from India, they did all the stuff in India. The jurisdiction really, the most convenient forum for the jurisdiction was in England where everybody was. The trustees were there, the beneficiaries were there. The assets were in different places, notwithstanding that, but the most convenient forum for them to hear and to deal with the matter was right there in London where everybody was readily accessible. So they're saying more or less the trustees voluntarily submitted to the court's jurisdiction because they accepted service of the writ. So the court had the jurisdiction to order their removal and replacement. The proper law of the trust was English law in any event. So, because in English and the Indian law was similar in this instance, but it was more or less that these trustees never paid any income or capital to the beneficiaries. They just had the money sitting there. So the beneficiary said, hold on, we need to remove them because they're not acting in our best interest. So it's not in the interest and welfare of the beneficiaries where they acting, eh?
But that doesn't mean that they were in breach though, right?
No, they weren't in breach. They asked them to be removed because what they were saying.
Because they weren't doing anything.
They weren't acting in the interest of welfare of the benefit. So if the trust is for my benefit and I'm not benefiting, who's benefiting from it?
So
the trust,
wouldn't it have been the rights of the beneficiaries to act, to enforce that the trustees do something?
so that's what they're doing is, no, what if you are a trustee and you're not acting in my interest or well-being, why would I continuously, that means I'm gonna have to force you every time it's something to be done, eh? Because you have already demonstrated you're not acting in my best interest. You see?
My question is, why wasn't it that the beneficiary is taking action against the trustees in this case?
Because the trustees were not paying anything out to them.
Right, so the trustees weren't paying anything out to the beneficiaries, so wouldn't the beneficiaries have a right to make a claim or something against it, like take it to court?
So the beneficiaries took them to court, but they took them to court to be removed. Because why would I want you to continue to be a trustee if you're not acting in my best interest?
Okay, I thought in this case it was the settlers taking them to court.
No, remember, who can enforce?
Right, the beneficiaries.
Right, only the
That's why I was asked, but I was confused because I'm thinking it should only be the beneficiaries who could take the court.
Yeah, it's the beneficiaries commencing action, seeking
Okay.
approval of the trustees and appointment of new trustees.
All right.
Because these trustees were not doing anything. They just had all this money sitting down and were not paying out any capital or income. There was never a distribution made. Okay? So if you're not acting in my best interest, or the interest of the trust, the welfare and benefit of the beneficiaries, and then the court will have to determine whether they have jurisdiction based on what? How they will determine if they have jurisdiction. Based on the facts of the case. That's number one. The jurisdiction of the court is which was dependent on the facts of the case. Okay?
Yes.
Go ahead.
Alternatively, in Reed Jordan 1919 LRGB 116, an application was made to the court in Guyana for the appointment of a new trustee. There were no trustees expressly appointed by the testator, but the three executors of the will were constructive trustees for the estate. The court granted the application on the ground that there were further acts to be completed by the executors, such as the protection of how do you say this word? Remainderment against the tenancy for life, then dealing with the remainder during the life tenancy. The three executors of the will were still trustees. However, the court found that they were unfit to act.
So in this case, they made an application for appointment of a new trustee because notwithstanding there were three executors of the will, they were actually constructive trustees for the estate based on the fact that they had a life tenancy. So who had a life tenancy we know before? Who had a life interest before in the 300,000? Amos, remember that? Remember Amos having 300,000 in the resulting trust?
Yes.
Okay, so in this instance, Amos had let's just say we use an Amos. Amos had a life tenancy, but there were beneficiaries named who would benefit absolutely upon Amos's death. So it wouldn't result. It was actually going down to some beneficiaries. So they say based on the fact that there was a life tenancy and there were beneficiaries to benefit after the person would have died, they want to protect the remainderment, which were the beneficiaries who would remain after the death of the life tenant. They want to ensure that they're protected and they didn't have any trust and confidence in the executors appointed because they would be trustees for life. What that means is if I have a life tenancy, so if I leave something for my husband, I have a house and I said, I want this for my children. So, but I want my husband to live here for the remainder of his life, so long as he doesn't remarry. The house isn't for my husband, absolutely. So he can't sell that house. The only thing he can do is live in it. The equitable owner is going to be my children. They are the beneficiaries. So in order to protect their interests, they are the remainderment, and to protect the life tenant, I should have some trustee there to oversee and to ensure that upon my husband's death, the property is properly conveyed to my children. which means that they would get a deed of what? If this created by will, they'll get a deed of assent, eh? So we need a trustee in place. I don't trust that the executive is gonna do what he's supposed to do. He's unfit to act. So I want you to appoint a new trustee, because as much as these executives would be constructive trustee barely by the fact that this has created a trust based on the fact that you have created a life tenancy and I'm not to get it until after the death of the life tenant. We need to appoint a trustee to ensure that the beneficiary's interest is protected during the life tenancy. You see that? You understand?
Yeah, I understand.
Okay. All right, go ahead.
Exercising the discretion. In the case of Re Tempest 1866, it was established that in exercising its discretion in appointing a new trustee, the court will consider the following: the wishes of the settlor insofar as they have been made known, the interests of all the beneficiaries, and the efficient administration of the trust. Certain categories of persons have been traditionally unsuitable to be appointed as trustees. A beneficiary under the trust, as they may act more in their own interest. The attorneys of the trust to a beneficiary. In modern times, it has been accepted that there may be an advantage to appointing a beneficiary as a trustee or an attorney as a trustee. In making an appointment, the qualities to be looked for include integrity, a willingness to spend time and trouble on the trust affairs, the ability to get on with co-trustees and beneficiaries, and knowledge of financial matters, business acumen, and common sense. In instances where the existing trustees refuse to act with the person proposed by the court, a balance must be struck between upholding the court's dignity and avoiding a situation where there is a serious friction between the trustees, which would be detrimental to the administration of the trust. After being appointed to the trust, the trustees are advised to take certain actions to ensure the preservation and protection of the trust assets. The trustee should review the trust instrument to ensure that he is aware of the specific terms of the particular trust and that he is knowledgeable about the provisions in the trust to avoid a potential breach in trust action. Additionally, he should review and inspect the trust documents accompanying the trust instrument, inclusive of trust accounts, notices, memoranda, trustee minutes, etc. As part of the inspection, the trustee should confirm that all trust instruments has been properly stamped and validated by the trust duty. All trust instruments executed after the 27th of July, 1998 are subject to a trust duty of $50 under Section 92 of the Trust Act, 1998.
Okay, so that's important to know, eh?
Okay.
And this trust duty is usually a stamp you affix. I think we talked about that already, or no? Affixing the $50 stamp to your trust document and canceling it. The trustees sign it they sign it and date it. That's how you cancel it out the stamp. But that duty is important to be affixed in order for you to use the trust. If you had the trust instrument, if you had a court action, that trust duty has to be paid in order for the court to recognize any trust instrument. Okay.
In addition to reviewing and inspecting the trust instrument and documents, It is important that the trustee ensure that the trust has been properly constituted by confirming that all legal formalities and requirements have been met to properly transfer trust property from the settlor to the trustee. Whether the transfer of the trust property requires a reconveyance of land, share transfer of shares, change in the ownership of bank accounts, the trustee must ensure, subject to the terms of the trust instrument, that he has legal ownership and control of trust property as soon as it's practicable, which is dependent upon the facts in every case. The trustee must also ensure that he invests trust funds promptly to minimize the risk of loss to the trust and a potential breach of trust action by the beneficiaries for failing to do so. He must also inspect the trust to ensure that there are no previous breaches of trust which may make him liable as a new trustee. Although he may have obtained a deed of indemnity from the previous trustee, indemnifying him against any previous breaches of the trust, upon his appointment, he may still risk exposure to a breach of trust action, as some cases have decided that deeds of indemnity may not go far enough in protecting newly appointed trustees, particularly those who fail to discharge their duties promptly and responsibly.
Okay, so this is now part of the trust team, the trust administrators ensuring that they are covered properly in taking on a trust, eh? So when they get the trust, they're supposed to review the instrument to ensure they're aware of all the terms of the trust, eh? And all provisions in order to avoid them being sued for breach of trust, eh? Yes? Hello?
Yes.
Yes, ma'am.
He should read all the memorandums. Which memorandum may be important for him to read? Memo of wishes? Remember the memorandum of wishes? Hello? Y'all remember the memo of wishes? What that tells me, what the memorandum of wishes tell me.
You mean the letter of wishes?
Remember we said the letter is from the settlor, but the trustee may want to do a memo to the file of the settlor's wishes.
So would that be like just like basically a guideline of how the settlement want the trust to be carried out?
Right, so we should read that to see what the settlor intended when he set up the trust, eh? Because we may get a request from a beneficiary that the settlor already said, watch out for him, he's a spendthrift beneficiary, and he just wastes money. So when use your discretion in dispersing any funds to him. So this memorandum is good. The trustee minutes is good to review as well to see what would have happened before. We should ensure that the trust instrument has the stamp duty affixed and it's canceled. And then we should ensure that all legal formalities and the requirements have been met to properly transfer from the settlor to the trustee, and thereafter we have to ensure that it's properly transferred to us as a new trustee. If there are share certificates, it was issued to UBS trustees as trustee of the ABC Trust. It should now be issued to CIBC trustee of the ABC Trust. We should ensure that the bank accounts, they've changed the names. So it's no longer UBS trustee, it's CIBC trustees. Ensuring all property is legally transferred to the new trustee. We should ensure that all trust funds are invested promptly because the beneficiaries will sue us for breach, saying they would have lost money because we didn't invest the funds promptly. Yes, and then we should ensure that there were no breaches before by the new trustees in reviewing the documents, and we should get a deed of indemnity from the new trustee to protect us from liability of what they would have done before. As much as it may not go as far as it should, it still gives you some buffer of protection because you still may have some issues if you fail to execute your duties properly and promptly, because if there was a breach before, if you had reviewed the documents, you would have been able to catch it and you would have been able to address it, you see? So you will not be protected where you've not done your due diligence. In the meantime, you still get a deed of indemnity for items that you may not be able to see on the face of the documents when you're first appointed as trustee. Okay? That's the end of it for you all? Or you all have more? There's anything else?
Yes,
You
ma'am.
mean to be read?
Yes.
No, there's more.
Okay. See, my book is, I don't think they updated this book. This is an older book, so go ahead and read for me. So how much more to read?
There's just, I think, the rest of this page, and then the other stuff seems to be just different cases.
So the questions thereafter then.
Yes, and then there's the question.
Okay, so you don't have much more to read then.
I guess not, no.
Okay, go ahead. I'll have to be following you because I don't have any more reading.
Okay, I'm trying to, can someone tell me where I stopped? I lost.
Discharge their duties promptly and responsibly.
Okay, yes. Okay, so retirement of trustees. A trustee may retire from the trust in 4 ways: by taking advantage of an express clause in the trust instrument. Number 2, under section 46 of the Act. Number 3, by obtaining the consent of all the beneficiaries being sejurers and absolutely entitled to the trust property. Number 4, by obtaining the authority of the court. Retirement without replacement. A trust may retire without replacement where at least 2 individual trustees or a trust company remain to administer the trust. The remaining trustees and any other person empowered to appoint new trustees consent by deed to the retirement. The trustee executes a deed of retirement. A purported, is this supposed to be proposed retirement?
A purported?
Yeah.
No, go ahead, purported.
Okay, a purported retirement which does not comply with the statutory provision is invalid. See the case of Jasmine Trustees Limited versus Wells and Hand, 2007. Retirement under an order of the court. The court may discharge a trustee under section 48 of the Act only where it is willing to replace the trustee within the power given by the section. The court also has an inherent power to discharge a trustee without a replacement in an action to administer the trust. Read Chetwynd Settlements 1902. This may occur where the trustee is not able to retire under the section or the trustee cannot obtain the requisite consents. Removal of the trustees. A trustee may be removed from trusteeship out of court where he remains outside the jurisdiction for a continuous period of 12 months or more, where he refuses to act, or where he is unfit or incapable of acting. He may also be removed and replaced by the court. In addition, the court has an inherent power to remove a trustee without replacement under the principle in Letterstead versus Breyers 1884, which is that a trustee may be removed if his continuance in office would be prejudicial to the due performance of the trust, and so to the interest of beneficiaries. Excuse me. Sorry. Fraud, bankruptcy, or gross incompetence would be grounds for removal, but it is not necessary for those seeking the trustee's removal to show misconduct on the part of the trustee. It is sufficient if there is friction between the trustees or beneficiaries or lack of confidence in the trustee. An example was in the case of D. McCarter versus City Trust, Bahamas Limited, 1986, where under the provisions of the trust deed, the corporate trustee had power to terminate the trust and pay the capital over to the income beneficiaries in equal shares. The income beneficiaries requested such termination by letter to the trustee, setting out detailed reasons for the request. The trustee rejected the request in a pre-functionatory manner, and after undue delay, the beneficiaries sought the removal of the trustee by the court on the ground that the relationship between the trustee and the beneficiaries was unsatisfactory, and that such removal was in the interest of the beneficiaries. Georges C.J. said, the principle to be applied in considering the removal of a trustee were discussed in Letterstead versus Boyes, the Lordship stated. Okay, before I finish reading, I just have a question so I could try to understand what exactly I'm reading.
Okay.
Especially with this, the example that they provided, D. McCarter versus City Trust. Can you explain more exactly what happened there, please?
Okay, you have to give me the name of the case.
It says D. McCarter versus City Trust Bahamas Limited, 1986.
Because I don't have that part, but it
Oh.
seems as if, I don't know if you all want to screen share it to me, because it seems as if the trustees were not adhering to the request of the beneficiaries, and it seems as if their relationship had broken down more or less.
Okay.
So the beneficiaries seem to not want to continue the relationship, so they approached the court in this instance.
Okay, so question where it says, in my book, it says the trustee rejected the request in a pre-functionatory manner. What does that?
So they just rejected it, just like, that's just a function, and they did it long before even considering the request.
Oh, okay.
So they just did it as a matter of course without even considering without really putting any effort behind it. So they call it perfunctory.
Okay.
So it's not as if they even considered the request, more or less. That's what they're saying. So without any interest in what they were asking about, they just rejected it.
Okay, so basically in their minds, they were done then.
Yeah, they were. Yeah, so it was just like, whatever.
Okay.
You asking? No. I already made up my mind long before you even asked. No, I'm not doing it.
Okay. In exercising so delicate a jurisdiction as that of removing trustees, their lordships do not venture to lay down in any general rule beyond the very broad principle that their main guide must be the welfare of the beneficiaries. Probably it is not possible to lay down any more definite rule in a matter so essentially dependent on details, often of great nicety. Earlier, their lordships had discussed the dearth of the authority in the area and had agreed that in practice, once issues of character had been settled, once it was clear that the continuance of the trustee would be detrimental to the interests of the trust, even if for no other reason than the human infirmity would prevent those beneficially interested from working in harmony with the trustee. The trustee is usually advised by his counsel to resign unless the trust instrument indicated a contrary intention on the part of the settler.
So in this instance, they are no longer getting along, and it's obvious there's an impasse they've reached. The trustee and the beneficiaries don't have a relationship, more or less. And it seems as if the trustee is just acting without regard to the welfare and interests of the beneficiaries. He's taken his own position, and unless the settler would have said something contrary to say why he would be acting in that way, it doesn't make sense for them to continue the relationship, more or less, because they're not going to get anywhere. Remember, we just said that with the other one with Chelaram and Chelaram, it didn't make sense for them to continue with those trustees, because the trustees never even made a distribution of income or capital to them. So why would I want to continue with you being a trustee? You have shown you don't have any interest in the well-being of the beneficiaries. So let's move on from you.
Okay. In this case, there were veiled allegations of breach and trust and rather direct charge of incompetence. Understandably, these had to be resisted, and I find that they have been disproved. I do find, however, that the charge of unresponsiveness has been made out, and I am satisfied that the relationship between the income beneficiaries and the trustee is such that the interests of the beneficiaries are likely to be affected. The income beneficiaries are both from the record competent and experienced at managing large assets, and the trust is likely to benefit from close collaboration between themselves and a trustee in whom they have full confidence. The trust instrument makes clear that the interests of the income beneficiaries are to be the primary concern of the trustee. Paragraph C of the 5th article reads, "The power vested in the trustee under the foregoing provisions of this article shall be exercised with primary regard for the interests of the income beneficiary of the particular trust, or to the extent the trustee shall deem appropriate. The interests of the members of her family and the interests of any other person shall be disregarded. In the circumstances, although I find that the allegations of incompetence and possible breach of trust have been sustained, I am satisfied that in the interest of the welfare of the beneficiaries, there should be a change. A more restrictive approach to the court's jurisdiction to remove a trustee was decided in the Bahamas case, Viso versus Chase Manhattan Corporation Limited. And that's the end of the unit.
Okay, and in Viso, I sent you in Viso. So in Viso, let's see how much reading this is. This is not much. JV created a trust and appointed GM trustee. The trustee was to pay the income and principal for the benefit of the settler as directed by the settler during his lifetime and to his surviving issue after his death. The trustee was also bound to deal with the assets of the trust in such manner as the settler might direct while he remained alive and not incapacitated, and the trustee was indemnified from liability for any loss flowing from the settler's instruction, but was not indemnified from liability for failure to take ordinary care. The settler took an interest in the GB Limited Partnership, which owned a commercial building in the United States. The partnership consisted of CR, the limited partner, which held 98% of the interest in the partnership, and CP, the general partner, which owned 2% of the partnership but had exclusive power to manage the affairs of the partnership. The settler decided to buy a 49% stake in the partnership from CR. GM, the trustee, also held investments in the partnership on behalf of other investors, and another company in its group acted as its investment advisor to both the partnership and CR, but did not itself have any beneficial interest in the partnership. Nonetheless, CM drew to the settler's attention the possible conflict of interest, and the settler signed a letter releasing CM from all liability arising from the purchase of the 49% stake in the partnership. It was agreed, however, that this did not release CM from its fiduciary duty to manage the assets of the trust prudently. The settler also directed CM that after his death, it was to hold the partnership interest for the minimum holding period. At the expiration of that period, however, the property market had fallen, with the result that the building was worth less than the outstanding mortgage. There was also a lessee who had the right to decide at any time in the next 8 months whether to continue the lease. CM commissioned appraisals of the building but did not sell his interest, nor did the partnership place the building on the market. Instead, it negotiated with the mortgagee and made an arrangement which meant that the trust had lost some $2.6 million. The beneficiaries applied for the removal of CM, alleging that it had failed to exercise ordinary care and that it had failed to sell the interest as directed, or alternatively, that it was necessary to replace CM as trustee in order to examine the affairs of the trust and determine whether CM had acted improperly or negligently. It was held that where a person of full age and understanding signed a document which is obviously intended to have legal consequences in reliance on the advice of another, but that person cannot subsequently be heard to say that document was not the person's document. Since the trustee was indemnified from any claim arising out of the purchase of the interest, any finding of failure to take ordinary care had to arise from the management of the interest, subsequently, and required proof of mismanagement. It was not the duty of the trustee to preserve the real capital value of the trust, nor were trustees to be judged by the risk attached to each investment in isolation, but by the risk level of the entire portfolio. Nor would every mistake or neglect cause the court to remove a trustee. The trustee could not be blamed for the fall in the value of the partnership's assets, and any claim that losses would have been reduced by placing the interest on the market was purely speculative. The plaintiffs had not shown that the trustee had made any decision without taking their interest into consideration. It would not be a proper exercise of the court's jurisdiction to remove a trustee without such proof, merely to allow investigation into its management of the affairs of the trust. In exercising any discretion, the court would be guided by the welfare of the beneficiaries. Appointment of a new trustee would have resulted in substantial expense, and there was no evidence that it was in the interest of the beneficiaries to do so. So that case, Visa v. Trust v. Chase Manhattan, notwithstanding the Chase Manhattan Corp took another route, notwithstanding they thought they should have went the other way. The court didn't see that they did not act. They acted out of the interest of the beneficiaries. So as much as they did not place the property on the market, but made an arrangement to dispose of its mortgage, they did so in the best interest. They thought they were acting in the best interest of the trust, so the court didn't see why they needed to be replaced. And if they were replaced, it would have been too burdensome for the trust to now get new trustees. So they acted, the court said no, they should continue as trustees. Okay, you all have that for reading, so you could look at it again if you want to.
Yes, ma'am.
Any questions? Okay, so let's go to our self-assessment questions. What are the general requirements to act as a trustee?
That's page 48, paragraph 1.
Okay, and what is that?
He must be of sound mind and not legally declared bankrupt.
Mhm.
Must be the owner of property, including real property. It is also required the trustee also be legal age to the 18 years, especially in light of the fact that minors cannot hold a legal interest in land.
So you must also be of legal age, which is 18. Okay, what is required for a corporation to act as a professional trustee in the Bahamas?
That's also page 48.
Okay, and what is
And they have to obtain a restricted license or non-restricted license from the Central Bank of the Bahamas.
correct? What are the three circumstances in which a trustee may be appointed?
Page 49,
Mhm.
paragraph 1.
And what is that?
Trustees are normally appointed in the following circumstances: at the creation of a trust, as a substitute for a trustee of an existing trust who has died, retired, or been removed, and as an additional trustee to an existing trust.
Okay. What document is typically used in the appointment of new trustees?
Is that a date of appointment on page 50?
Page 50, that's your page 50. Deed of appointment, which document is typically used? Okay, that's your page 50. Read it for me, because if, we have different.
It says the appointment of a new trustee is normally made by a deed of appointment executed by the parties, particularly where a new trustee has been appointed to replace a retiring trustee or as an additional trustee to an existing trust.
Okay, I have the same thing. Okay, it's just a different page. Okay. Okay, and beneficiaries are required to be blank and blank to be able to appoint a new trustee.
I was looking for that. I haven't found it yet.
Okay, I have that as my next page. 40, that's my 45. Beneficiaries must be sui juris. Alternatively, see that beneficiaries must be sui juris and absolutely entitled to the whole of the trust property to appoint new trustees. Y'all see that on your page?
Looking.
Around this part, I have the section 42, one of the trustee act, and additional trustees may be appointed as long as the total number does not increase beyond 4.
Has anybody come across it in the new book?
No, and I was looking for that for a minute and I didn't see anything.
Okay, that comes right after. New trustees may be appointed not only by persons nominated in the trust instrument, you all have that paragraph, but also by surviving or continuing trustees or personal representatives. You all have any paragraph right
Yeah,
before?
that paragraph is on page 50.
Okay, so under that paragraph, you all have anything but alternatively beneficiaries who must be sui juris. You all have nothing but beneficiaries being sui juris.
I don't see that.
It's before appointment by the courts. Mistakenly take that all out. You all have nothing but the beneficiaries being able to appoint trustees.
Don't see that.
All right, this was my page 45, and this was right above appointment by the courts. What you all have around section 42(1).
That's where it talks about the rules related to the appointment of a trustee.
And you all have nothing in there but beneficiaries?
No.
Okay, well, put it in there that beneficiaries are required to be sui juris and absolutely entitled to the whole of the trust property. To be able to appoint a new trustee, so I think they need to make note that that has been taken out, so y'all would know that.
Can you repeat the answers, please? They have to be sui juris and
Absolutely entitled to the whole of the trust property. Got that?
Ma'am.
yes.
Considerations does the court make in seeking to appoint new trustees? Where we'll find that answer.
That's 52.
Okay, and what that is?
The court may appoint a new trustee as a substitute for a trustee that has died, retired, or been removed, or as an additional trustee to an existing trust, taking into consideration the wishes of the said law and the potential trustee's impartiality and his ability to further the interests of the beneficiaries and the trust generally in section 48 of the Trustee Act.
Okay, and what case tells us, what are the 4 points that the case tells us? So we should refer to Chalaram.
The jurisdiction of the court, which was dependent upon the facts in this case, the interest and the welfare of the beneficiaries, the actions of the trustees, those trustees who acted improperly or dishonestly and endangered the trust assets could be removed, and the nature of the duties to be performed by the trustees and whether such duties were of particular personal or delicate nature.
Yes. Okay. What action should a trustee take prior to appointment as a new trustee? Where we'll find that answer. See that?
Currently looking.
Now that was my page 44. Would have been your what? But your first page is of unit 5.
48.
So look on your page 49 under appointment of trustees. Do I see anything about appointment? It is important that trustees disclose any potential or existing conflict.
Yes, ma'am.
Okay, so that's it there. Read that one.
It is important
Which
that
page, please?
that's 49.
Sorry. Okay,
That's above the appointment of the new trustees.
okay, thank you.
It is important that the trustees disclose any potential or existing conflict of interest prior to their appointment to a trust, as it is fundamental principle of trust law that a trustee may not place himself in a position where his duty as a trustee conflicts with his personal interest.
Okay. What case tell us about that? Hmm? You remember Boardman and Phipps? He takes some shares from the trust? And then-
Yeah,
Yes.
and he invested in it, and
So that's your duty, conflicting with your personal interest, you profiting from your position, or teaching Sanford as well. Okay. What action should a trustee take after appointment as a new trustee?
after being appointed to the trust, on page 53, the trustees are advised to take certain actions to ensure the preservation and protection of the trust assets.
What he should do?
You should take certain actions to ensure the preservation, preservation, and protection of the trust assets.
Right, so he should do what? Review the trust instrument. Go ahead.
Oh, yeah. To review the trust instrument to ensure that he is aware of the specific terms of the particular trust and that he is knowledgeable about the provisions in the trust to avoid a potential breach of trust action. Additionally, he should review and inspect the trust documents accompanying the trust instrument, inclusive of the trust accounts, notices, memoranda, trustee minutes, etc.
Okay. What is a trust duty?
It's the funds you pay for the stamp.
Okay, and how much is the trust duty? The trust
$50.
duty is, okay, is the
$50.
fund you pay for the stamp to be what?
Validated.
Validate the trust instrument, right?
Yes.
And what is the duty?
$50.
$3.
Why is it important to inspect previous breach? Maybe we'll find that answer first before I move on. Where do you find number 9? Everybody will
It's
know.
important to inspect it so you're not held liable.
No, tell me where number 9 is first so they'll know where to look. Everybody know where number 9 is?
Page 53.
53.
Okay, now number 10, why is it important to inspect previous breaches of trust after appointment of a trustee?
To ensure that he will not be liable as
Where
a
we'll
new
find this
trustee.
answer. Where we finding this?
Page 53.
Page 50.
Okay,
Page
go ahead.
54.
You must also inspect the trust to ensure
There are no previous breaches of trust which may make him liable as a new trustee, although he may
right.
have obtained a deed of indemnity from the previous trustee, indemnifying him against any previous breaches of trust upon his appointment. He may still risk exposure to a breach of trust action, as some cases have decided that deeds of indemnity may not go far enough in protecting newly appointed trustees, particularly those who fail to discharge their duties promptly and responsibly.
Awesome. You all have any other questions in your new book?
No, that was the last question, number 10.
So how and when trustees are appointed to a trust? Mm-hmm.
The creation of a trust. As a substitute for trustee in a existing trust.
They may be appointed at the creation of a trust or as a substitute for a trustee of an existing trust who has died, retired, or been removed, or as an additional trustee to an existing trust.
What action should the trustees take before appointment?
they should review the trust instrument to ensure that he is aware of specific terms of the particular trust
So this before he's appointed.
before he's appointed.
Yeah. We just look for it and find it.
Or, so he should review the trust for potential breach of trust?
No. Again, we do this before appointment. He can't review the trustee. He's not appointed yet. Just before appointment.
He should disclose any potential or existing conflict of interest.
Right, right. And what information he should gain on requirements to act as a trustee. Versus requirement, what are the requirements for him to act as a trustee? What are the requirements? Act as
He
a
has to be of sound mind and not legally declared a bankrupt. And he has to be of legal age.
Right. Now, what laws deal with the appointment of trustees? What laws, how we deal with the appointment of trustees? What guides us?
Section 48 of the Trustee Act.
So it starts with section 48 or 42?
42, sorry.
42, and then 48 dealing with, who deal with 48 or what?
Appointment by the courts.
Right. See how good y'all getting at this? Y'all know the sections right off the top. What section 24 deals with? What section 24 tell me?
The trustee may insure themselves against liabilities except for breach of trust.
Power to insure, correct. What section 83 deals with? Remember section 83? The right of information of the beneficiary. You remember section 83? The beneficiary's right to information? What right to information the beneficiaries have? What right of information the beneficiaries have? You remember? They could get minutes?
No, right?
No,
They
That
could
could be a
get,
conflict.
they
They could
could
use
get
that
account information.
against the trustees.
Right, so they could get what? What you said? Someone just said it. What they could get?
Is that the account information?
Yeah, they could get account information as long as they're willing to do what?
Pay for it.
Right, that's really what?
Watson.
Yeah.
Watson.
Yes, you see, you all get this, you all getting it. So you see how much that helps you when you could put these, so as much as you answer and you put these little references, it gives you a little extra point, okay? So that's why I want y'all to remember what section 3 tells us about the settler. We just talked about that.
They could reserve rights.
They could reserve some powers, eh? They could reserve some powers to themselves. What was the leading case dealing with the sham trust? where the trustee was only a puppeteer. Ramen case, that's right. And when I'm talking about resulting trust, I'll remember, what case I'll remember for resulting trust?
We abort with Amos.
Say it again?
It's we abort with Amos.
Okay, and what is it? Say it again?
And we Vanderbilt's trust.
Yes, yes, yes. Okay. Any questions? Any questions?
No question.
Okay, so units 1 to 5 clear then.
Well, a little bit more reading it should be.
Okay, so I sent you some information that y'all could, some cases you could read if you have time. And then I sent you some questions as well, which may help you to refresh on some of the past units we did as well as current units, okay?
Yes.
Yes, ma'am.
Okay, you all do well, and I wish you all the best on your exams.
Thank you.
Thank you.
Thank you.
So you all have,
Thank you.
I think you all have Ms. Archer next week. I'm not sure, Ms. Archer or Mr. Wilkinson.
We have a guy next.
Yeah, I think it's Mr. Wilkinson.
Yes, okay then. So do well and thank you.
Thank
All
you.
right.
Thank
Thank you
you.
so much.
Hi, Ms.
Thank
Dawson.
you.
Hello.
She's gone.
Oh,
She left.
okay. Thank you.
Yeah.